Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning, focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk to you about qualified income trusts and a bad power of attorney, or maybe just a not as superior power of attorney. But before I do, I want to invite you to schedule a free strategy session with me at eldermeeting.com. So sometimes people come to my office, we review their existing documents, their loved one may already have capacity issues, and it's time for a qualified income trust so their loved one would be able to qualify financially for Medicaid long-term care benefits. And upon review of our durable power of attorney, we realize that it does not authorize the agent to create such a trust on behalf of the principal, meaning on behalf of the person who needs the benefits, who needs the income trust. So what do? Are we now left with a guardianship, or are there other alternatives? And thankfully, there are other alternatives, meaning that we can petition the court. It'll still require court intervention, but we can petition the court for permission to create this qualified income trust. There are federal rules that permit by court order for a person to be able to establish a qualified income trust for a person who has needs for this trust for purposes of qualifying for Medicaid benefits. So you can avoid the need for full guardianship and all of the supervision and reporting requirements associated with the full guardianship, because you still do have lesser restrictive alternatives in place, meaning you still do have a valid durable power of attorney. Most likely you'll have some sort of healthcare surrogate document or other appropriate planning documents in place that will serve their purpose and avoid the need for guardianship. But really, you just needed one little act from the court, which was permission to create this type of trust. So while it's really important to make sure that your documents are comprehensive so you can avoid having the expenditure of a court proceeding, such as asking permission to create this trust, you're not completely dead in the water, or you're not completely left with a full guardianship should your documents not have this one particular clause. So that's important to know, but also it's just really goes to show why having strong documents are important, and why just working with a elder law attorney who is savvy and forward thinking is an important thing to do. I hope that this information has been helpful. If it has, I ask that you like and share with others. And as always, feel free to schedule a strategy session with me at eldermeeting.com. Thank you for joining me.